We are live now, sir, on our channel. And a warm happy evening to all the participants who are joined with us to gain the knowledge. I am Nirmal Kumar Jain, a law student and the founder of Law Gardener. On behalf of Law Gardener and team, I welcome Advocate Jamshed Mistry sir, who have come here and gave their time from their busy schedule to share the knowledge on public interest litigation and use of technology in litigations. I would also like to welcome all the participants, which include law students, lawyers, and common man. Before starting the session, I request Miss Avni P to give brief introduction of our today's guest. Over to you, Avni.
Good afternoon, everyone. I am Avni Punjawat, pursuing law from Dr. Ambedkar Law University, Jaipur. Let me introduce Mr. Jamshed Mistry, sir. Mr. Jamshed Mistry have done LLB from Law College, Mumbai, and PG Diploma in Labor Laws and Welfare from Dr. Ambedkar College of Law. Sir is founder of internationallegalalliance.com, a virtual global network for lawyers. Sir is member of Bombay Bar Association, Intellectual Property Right Practitioner Association, Associate member of Canadian Bar Association, Advisory Board member of South Asian Fashion Week. He is also the life member of various organizations like World Zero European Chamber of Commerce, Indo-Iranian Chamber of Commerce, France-Asian Chamber of Commerce, Knowledge Chamber of Commerce and Industry, the Lions Club, Baikula, District Chairman, Legal Issues, Lions Club International, Honorary Board member of Asian Chamber of Hospitality Industry, advisory board member of ADOPT and chairman ADOPT Rights Group, member of College Development Committee of Praveen Gandhi Law College, Mumbai. Sir has wide experience of litigation, international law, media and international law, medico-legal and social issues and causes, etc. Thank you.
Thank you, Avni, for giving such a warm introduction of our guest. And as we know that PIL is a power given to the citizens of India by the Constitution and power to approach the court to maintain the public interest. And we know that there is a need of technology in the judicial system. But though the executive and judiciary are working towards it from many years, but during the time of pandemic, a nationwide lockdown was imposed. Difficulties arose to avail the justice. But in the last 1 year, a rapid change was seen and judiciary tried to move into the virtual hearing, though it had its own pros and cons. And now we will hear from the sir their experience about PIL and technology. Now I request sir to take over the session further.
Thank you very much, Nirmal, and thank you for a kind and a warm introduction. Yes, the topic for this evening, with a good evening to all, is is public interest litigation. So I'll dive straight into the topic. Now, as we all know, public interest litigation is something that came much later to the shores of India. One of the early sort of signs of public interest litigation was very interesting. In fact, I'll skip England and other places. It came in little later, but it was in fact the United States of America that actually had public interest litigation as a uh, uh, as a form where the Supreme Court of the United States had occasion to actually look at a letter that was written to them. And it was very interesting. The question was that could a person who was insolvent could he actually represent himself? And that question, by I think a majority of, I think 7-1, they decided that yes, you could, you know, allow him, because otherwise you had to appear through, at that time, barrister or counsel. But they allowed this person to appear on his own, because he said he could not afford a counsel, and that was perhaps the first sign of public interest litigation. In India, it was actually in the 1970s that we found the famous Doon Valley case, where again a NGO wrote a letter petition to the Supreme Court of India saying that there was illegal mining in the Doon Valley, and that too was taken up as a letter, and the court issued notice to the authorities as well as to the mining companies, and that was probably our first experience with public interest litigation in the 70s. Over a period of time, it has kind of, uh, uh, changed, in the sense that, earlier we only had, you could approach the court under Article 226, 227, and the Supreme Court under 32, uh, as in by way of for a public interest litigation. Or, as I said, that a letter that somebody wrote to court could be converted into what is called the suo motu petition by the honorable court, and taken up. Now, I will proceed for the experience that I've had as a lawyer. I actually did my basic sort of practice and started as a labor and service lawyer. But in fact, it was in 1998 that we first came across. And in fact, it's very interesting, because my first public interest litigation that I appeared in was actually for a respondent. And this was the famous, it was called the Smoke Affected Residents Forum. There are, for those who are familiar with Mumbai, there is an area called Chembur, where there is a lot of, sort of refinery and other pollution, but there was also pollution from automobiles and buses, trucks, etc., on the road. This was following the MC Mehta case in Delhi, where they said that, you see, these Blue Line and other buses were polluting, and also there was a need for these. That time, we were using the 137D taxis, which were polluting, and therefore there was a need to shift to an alternative fuel. So, in fact, I, with my two senior colleagues, appeared for the BEST, the Bombay Electric Supply Transport Undertaking, where they have buses in Bombay. And, it was very interesting, because you suddenly found that that this what was being discussed was a little bit like a science lecture, where there was chemical were being what was being thrown out as pollutants, and this new gas called which used to be thrown out, and as an exhaust, or rather as a waste product, called CNG. And that CNG apparently was something that if was fitted into vehicles, it could be used as fuel. It was sort of a learning for us. And then we went back. And yes, I must tell you, initially the court was completely against us. They said, no, nothing doing. At the highest, BEST must be, better than Bihar State Transport, undertaking, and there is no question. And you have to convert all your buses to CNG, otherwise we'll stop the transport undertaking, etc. So I remember, in those days we didn't have mobile phones. We all were using little pagers and coin box. So I went and I called up the then general manager of BEST and said, "Madam, listen, please, they want to stop. We have to do something." So it was very interesting. The chairman of BEST and we all met in their office, and we said, let us see if we can do it in a phased manner. Now, what was interesting was the BEST undertaking was actually, because it ran about a 3,500 bus fleet. It used to do the distance from here to the moon in kilometers annually. Uh, so we said that, what were you doing? They said, we change our engines without fail every 4 to 5 months anyway. We said, okay, that is very good, but let us see if we can get some more time from the court. And you have to appreciate, in those days, CNG was, newly, I mean, the gas was obviously available, but the machinery, which used to be imported from Italy, that took a lot of, it was very expensive and a lot of time to bring to India. So, we were able to show the court that, this is what we are doing. And then, the court understood, and in fact, they allowed the BST buses to sort of, go ahead and, phase the old buses in a phase, sort of in a better phase out manner. Even the diesel buses were slowly phased out. Now the net result, and I must tell you, several years later, the legal manager of BST once met me and said, oh, you know what, thank you so much for all that you all have done. In fact, now this part, we are not only running the buses on clean fuel, but we are also now introducing electric buses. So I think we were able to contribute in a substantial way, and to ensure that the commercial capital of India moved to a cleaner fuel through the subject of law, although we were on the other side as a respondent. So this was my first experience. Then, of course, we had a orthopedic surgeon, one Dr. Sarosh Mehta, who actually came and met me for another problem in regard to Mumbai city. Now, he had witnessed one of the most horrific accidents on the railway tracks. He had actually got down, and he had found that somebody, but very severely, because that person had fallen from the local train, and he went down to see that, and being a doctor himself, but he was absolutely horrified the way in which the person was, bodily lifted. He said the stretcher only had paper and not even cloth. And he said that person was sort of put into a auto rickshaw, and I don't know where he was taken. So this doctor went at that time. I think this was before the Right to Information Act came into play. He went to meet the railway commissioner, and he said, tried to find out that how many such accidents take place. And he was absolutely horrified. They said that out of every accident that happens, every second person would normally not even survive. So it used to be so fatal. So that means 1 out of 2 persons used to die falling from railway tracks, and it used to be somewhere around, I think, 10 deaths a day. So he decided to file this particular petition. And what happened to him was also very interesting. Initially, of course, when he went to the High Court, the court said, doctor, how can we help you? So he said, no, I know that this court is a very powerful mechanism, and this is what we want to do. The railways came back and said that we are not responsible for the deaths on our railway tracks. So this argument apparently went on. Finally, I think the petition was dismissed on the ground that by a bench, saying that the railways are not responsible for the overpopulation of the city, hence petition dismissed. The poor man was in complete shock. He actually met me and he said, I need to do something. We need to go to the Supreme Court. I said, let's wait. We allowed the 2 judges who had passed the order to retire. We filed a review petition. We went before I think the Chief Justice and I think it was Justice Chandrachud was the other judge, and I pointed it out. I said, "I'm sorry, this is absolutely unacceptable, and you need to certainly review this. How can the citizen be responsible for falling off from local trains?" And the court immediately agreed. They restored the petition, and in fact, it was this petition went on, and I think it went on for almost 18 years. The I think in 2006 we had a terrible series of blasts on the suburban railway tracks, and I think remember going back to court, and we had our former Chief Justice of India, Justice Lodha, presiding over a bench in Bombay. And I remember telling him that, when these blasts happened, there was, there was nothing. The golden hour principle, which is to be followed, that means medical treatment has to happen immediately for for the success of somebody actually surviving. Uh, there was absolutely no steps, nothing was taken care of by the administration, or even emergency procedures were not in place. And in fact, the court then called the additional solicitor general. We sat down and we framed an entire scheme for how in cases of emergency this should be done. uh, Thereafter, in 2008, one activist called Mr. Samir Zaveri, who had lost his legs in a similar, railway accident, he filed a petition saying that Dr. Mehta's, matter, the orders passed therein had not been complied with. In that case, I was appointed by the court as the amicus curiae to assist the court. And in Mr. Zaveri's case, we actually I even traveled by local train from with the train driver to see. And sometimes it is absolutely terrible. In those days there was no proper fencing, so the engine driver used to say that, "Sir, if I try and stop, the bogies at the back may." So I said, "What do you do?" He said, "We just continue, we just go." I said, "That's you know I'm sure you all must be suffering from post-traumatic stress disorders if you just uh, continue." So then the concept of introducing fencing, ensuring that on each railway station or close by to it there is emergency medical equipment and everything is available. Also, the nearest hospital had to be given guidelines, although there was, Katara's judgment which said that, doctors, etc., must, immediately be given priority, and, police should not bother about, taking their statements and calling them to give evidence. So all these aspects finally ensured that the number of deaths on our suburban railway tracks has, I mean, I'm happy to say, have drastically reduced. The railways have even accepted the fact that yes, they are partially responsible in case something happens on their premises. So I think this was a great success. It took close to 17 or 18 years to get this done, but I think finally every life counts, and I think that's the best success that a PIL can get. Uh, Apart from that, I was also, it's very strange sometimes how, you get cases. A journalist one day came running and telling me, he said, "You have been made amicus curiae in a hospital case." I said, which is that? I have no idea. Haven't received any papers. So apparently, again, under the Bombay Public Trust Act, certain number of hospital beds were supposed to be kept vacant for poor and indigent patients, and that was not being done by several public hospitals, private hospitals, sorry, who were charitable hospitals. So therefore, they came under the purview of the charity commissioner. and they were supposed to keep 10% of their beds vacant. That was also very interesting. I met the charity commissioner. I said, "What is the problem and why is this not happening?" He said, "No, this is a serious issue." So he sent uh, you know, somebody from his office in sort of slightly tattered clothes to a charitable hospital, saying that I need to get treated, and do you have a vacant bed for me? And apparently the security people sort of drove him out and said, it's better that you go away from here and please don't come. So we filed the gentleman's affidavit in court, and I think, of course, he is now a judge of the International Court of Justice. Justice Dalveer Bhandari was the Chief Justice. I remember he got so upset and he granted a stay immediately, saying that because these private hospitals used to get a lot of benefits. Like, for example, if they brought in machines, then they would get tax and excise and other benefits for the equipment that they could use, where they had to use this equipment for the poor and indigent patients. So obviously they were not doing that. So then all the hospitals, most of their sort of head of administration used to be ex services people. So he said, oh, they came and met me and they said, I'm Major General so and so, and I'm Brigadier so and so. I said, see, listen, if you want to sit down and talk to me, as far as the court is concerned, I am field marshal. They are going to listen to what I say, but let us find a plan and let's find a solution, and let's get this thing resolved once and for all. So they agreed. So we actually sat down and formed a plan whereby at least 2% of private charitable hospitals' monthly income was set aside for poor and indigent patients. And because we understood that keeping beds vacant, didn't really make sense, but at least this was, and of course, uh, if there was an emergency, no question asked. It didn't matter which strata of society you came in, you were to be admitted immediately. So this plan or the scheme was presented to the court. The court not only approved it, it went back. The state government, in fact, ensured that was now again constitute a scheme under Section 41AA of the Bombay Public Trust Act. So this is a classic example of somebody coming to court and in the absence of a law, or the court made law, or what was agreed between the parties, then goes back to the statute book. And I think this is again a very fine example of how a PIL can actually contribute to the making of the law, especially where there is a vacuum. So that was one. Then yes, uh, for persons with disability, that was another very interesting matter. In fact, what happened was, there's an organization called ADAPT, that is the former Spastic Society of India, and I had met actually two of their members, because in those days we were, involved in, forming resident associations, etc. So they said that, a lot of us, there aren't enough, I mean, there are a lot of physical barriers actually, and there aren't provisions for us, especially with regard to public transport, etc. And a PIL was filed in the Bombay High Court by students of the ILS college from Pune. So they came to me and they said, we would like you to represent us, because we find that, nobody is giving the disability sector's perspective to the court. So on the day in which we filed our intervention application, in those days, also, taxis, etc., the security was not that much of a problem. So the taxi could come right in. So, and if you've seen the Bombay High Court, it's an old Gothic building. So I found that these two people, both of whom were on a wheelchair. It we they were had to be physically lifted, then brought to the lift, taken to the first floor for affirmation of their affidavit, then taken again to the second floor where the central court room is, where normally the Chief Justice sits. And of course, when the matter got called out, I made the application. The application was allowed. Then, suddenly something struck me. I said, and I'm say this exactly how we address. I said, my lord, I'm really sorry to say, but we pride ourselves as the best high court this side of the Arabian Sea, but it took almost 1.5 to 2 hours for the applicants to come from the ground floor to the second floor of this court. And I said, without help and assistance, it would have been impossible. So the court, again was quite shocked, and they said, okay, we'll look into it. So I sat in court because I had some other matters there. I think it was the 1 or 2 matters later, the court called me back. They said, Mr. Mistry, you brought it to our attention that we don't have, proper facilities for, persons with disability. We have in fact allowed the use of the judge's entrance till such time as such facilities are provided for the court. Now, I thought that was absolutely, fantastic and brilliant, that the court showed compassion. The court showed that, yes, there is a need, that, a person with disabilities has equal right and equal opportunities and must be given that. And therefore, they allowed, the use of the judge's entrance, if you can imagine. Now, well, that was not that. Couple of weeks later, my advocate on record called me and started laughing. He said, you argued that before the court. Just see what they have done. So I went to see. I was absolutely horrified. They had cement concreted some steps, put a rickety railing and said ramp. So I went back to open court. I mentioned the matter before the bench, and I said that I'm really sorry. I said a perfectly normal person is likely to get a high percentage of disability if he uses this so-called ramp. I said, so Chief Justice was very upset. He called me in his chamber. He said, what do you want? I said, please immediately demolish this, and why don't we get a proper architect who knows the design, and with the Public Works Department to actually design this ramp. So that actually happened many years later. And in fact, for the first time, I think the then Chief Justice and, I don't remember who the second judge was, they actually came out and, they spoke to the, to television on the litigant side, and actually saw how the ramps, railings, and toilet blocks in the Bombay High Court were actually done. This also led to, for example, in Goa, which is a part of the Bombay High Court, a similar petition was filed by law students of the Salgaonkar Law College, and they asked me to appear there. We went there, and a comprehensive plan for persons with disabilities was actually framed with, the assistance of, the government and the NGOs. And so much so that I think the Secretary Social Welfare Department, who was being threatened with contempt of court for not following the law, finally he received the President's Medal for the most progressive state. So I think, PILs, and once you can change people's mindset, I think you can get amazing results as a result. Of course, I had also had the great fortune or misfortune to appear against my own school. Why? Because, again, they had dismissed a student. Why? Because he was suffering from what we call as learning disability or dyslexia. And I had appeared for, in fact, the Counselors Association, and there again, the court was, I would say, kind enough to actually look into the whole problem and actually again frame rules. And as a result of that, today, I mean, lakhs of students are all over the country are actually getting the benefit for more time, for easier subjects, etc. in the space of learning disabilities, which include dyslexia, dysgraphia, dyscalculia, etc. Uh, yes. 26/11, that was another, I mean, we've just passed the anniversary of 9/11. So 26/11 was a real problem in Bombay, where we had the terror attacks. There also, it was very interesting. Not the terror attacks, but the fact that we found that there was, huge gaps in security and security lapses. In fact, I had appeared for an advocate of the Bombay High Court, where we found that real-time Google Maps were being used, and it was very interesting that probably one of the rarest occasions, because you see, under the Right to Information Act, defense has the right to refuse to give information under that act. But for the first time, they had actually said that yes, that is they agreed that there was a lapse, a serious lapse, and in fact, they said that we will look into this aspect of real-time Google Maps, which apparently the terrorists used to attack. And this was actually brought to the attention of the court, and the court uh, said that yes, the Ministry of Defense will look into this. So what was unique was the fact that the ministry actually gave information under RTI, although it was, in an area where they could have said that no, this is, not permissible. Uh, but they did, and in fact, as a result of that, the petition actually succeeded. So that is quite unique. Yes, and I mean, surely as law students, one of the other very interesting cases which I certainly consider that was done in public interest was the famous Nikita Mehta abortion case. The reason why I say so is, in 2008, again, when we filed the case, there was absolutely no law in India. The Medical Termination of Pregnancy Act said that anything over 16 weeks was an offense, and the doctor, the hospital, clinic, everybody, could be punished. In fact, if they did or they performed the termination of pregnancy. And the Dr. Datar, very famous gynecologist, he came to us and said that, I have a client, and I think that there is a danger to both to the mother and to the fetus, and we need to do something about it. I said, all right. So very important research, especially as law students, I'd like to emphasize. So we started researching. I could not find any law, on the subject as far as India is concerned. So I referred to British precedents. We went to court, mentioned the matter, what it listed. The court heard me, heard Dr. Datar, and they actually decided to form a medical board to actually look into this aspect with the chairman and a gynac, a child specialist, and other persons on it. And now there also, what happened is, of course, we had filed the case as Dr. Datar, Mr. X, Mrs. Y versus Union of India and others. But again, unfortunately, the press sort of, in their over enthusiasm, they followed this the client, and the next day there was, the headlines screamed that Nikita Mehta goes to JJ Hospital for a, a test. Now that again brings up the role of the media, and whether is it sensitive to such cases or not. Of course, we had to completely ignore that and continue to serve the client's need. So we argued. I was asked rather sort of searching questions by the benches in those days. I remember that, Mr. Mistry, are you saying that every sort of case where there is a chance that the child might be deformed or whatever, you will want to terminate? I said, I said, you know what? I said, this is an exception to the rule and not the rule. I think that is very, very clear. And I said, fortunately, my experience in arguing matters with persons of disability came very useful at that point of time. Of course, then finally, on the last day when it was heard, unfortunately, I couldn't be there because I was engaged in another matter in some other court uh, out of Bombay. But the court said that this needs constitutional amendment. And I'm, happy to say so many years later that constitutional amendment has come, and exactly what we had argued at that point of time is now the law. So it's again very, very interesting on how uh, these things have changed. Uh, I will now move to the next aspect about technology. I mean, I think I'd probably take a couple of hours more if I had to keep talking about PILs.
Sir,
Uh, yeah.
pardon me, sir, for just I have we have various number of questions on the technology also, so we can deal with the Q and A, so we can cover every aspects, whatever the questions
I'll
are.
just
Yeah.
I'll just give a few comments first. I'll just
Yes, sir.
say what I
Yes,
have
sir.
to. Sure, thanks. Again, it was a I had the good fortune to travel to Canada, and that's when I actually saw how technology was used in the Supreme Court of British Columbia, and it was very interesting. It was where my client actually had, he was basically given, uh, he was sort of hauled up for criminal contempt because he had written a blog, and in that blog he had criticized the then Chief Justice of the Supreme Court of British Columbia. The Supreme Court of British Columbia is equivalent to our high courts. They have a Supreme Court of Canada, of course. And the question was, and in his defense, he said truth and public interest is a defense. The other side, that is the Crown, which is equivalent to our, government council, they said no, nothing doing. And this is a very interesting. This is an 800-year-old law that is still on their statute book, saying that if you commit this crime against the Crown, in those days it was supposed to be death penalty. Okay, so this poor gentleman was actually arguing on his own, and he said, "I need somebody to assist because there is a common law. Common law is what was basically practiced, in England and Commonwealth countries." So when I actually went there to appear, I found that at the end of the day, the client comes back to me with a sheet, with the booklet of like papers. So I said, "What is this?" He said, "This is today's transcript." I said, "Really?" I said, "This is very interesting." He said, "Yes." So whatever was said in court actually got recorded. And I said, "This is amazing." The same client then comes with me back to India, and he witnesses me arguing a case, the public interest litigation before the Bombay High Court. And at the end of it, he said, "Where's the transcript?" I said, "I'm sorry to say, but transcripts are imaginary. We don't have this system here." So he said, "Don't you think it's important?" I said, "I absolutely agree with you." I said, and so in 2017, when several persons, including senior advocate Indira Jaising, filed public interest litigation in the Supreme Court, saying that we must have live streaming, we said yes, not only live streaming, but along with that, we must have transcripts as well. And that journey was very, very interesting. So it's now called Swapnil Tripathi and others versus the Union of India. Uh, the back back end of it was very interesting. We've had several in-depth discussions with our Attorney General and so many others who were not aware that such technology was available all around the world. We gave all that information. We even submitted it to the Honorable Supreme Court's E-Committee. And the best part is that under the vision document that the Honorable Supreme Court E-Committee has come out with, that is for the next 4 to 5 years, transcripts with translation. Of course, live streaming is been approved, and of course, there are certain guidelines. Because certain cases you cannot have it. So that was one, and then the follow up of it. Because we filed applications in different high courts. Gujarat was the first to come up, and it is for all to see. I mean, currently, every single courtroom in the Gujarat High Court is being streamed live, which is good. I mean, hopefully this will happen, throughout the country. The objective is what? It's not so that it becomes difficult for the judges or for the lawyers, or that people will start play acting and things like that. No, the objective is transparency. Let me give you a very good example. The Maldives, for example, where there are different islands. How do you get in touch with each other? How do you approach the Supreme Court there? Again, everything was online there. They were practicing this way before us. We did. Be interesting to note, Pakistan has actually taken our Swapnil Tripathi's case, and under their right, to what do they call it? The right to legal information, or legal awareness. Their Supreme Court has issued notice saying that administratively they must have live streaming and transcription. So it's very, very interesting on I think some of the best examples are the International Court of Justice, the UK Appeal Court, etc., where not only your day's proceedings are shown live, transcripts are freely available, and at the end of the day, they have another very interesting section, especially for the media, because sometimes, media reporting, we are still, if you watch, even today, the Pegasus case, they're sending messages from somebody who was either present online, or if they were in court, that is only part of it. That is the understanding of the reporter. In these other cases, it is live, it is transcript, somebody can watch it, but not as a member of the public. You can't interfere with the court's proceeding, which is absolutely fine. So all these things are available. The courts even sometimes come out with press releases and statements that when we have given this judgment, this is what we have actually asked for or meant. So I think they're very simple. Technology is at least as far as court proceedings are concerned, it's very interesting. If you adopt technology, its implementation is immediate. It doesn't take time. So whatever happens very, very quickly. And I mean, we are living in such a fast age. People are talking about cryptocurrency, for example. Where are our courts? Are they even? I mean, of course, India has yet to sort of accept its validity. That's a different story. But today, if somebody owns a crypto asset, how does he or she even think worldwide of how to get justice? I mean, there's nothing. Our courts, our civil courts, it will take so much time anyway just now. So I think these are, technology is sort of, is taking charge of us. I mean, yes, some questions about your artificial intelligence and this and that. I mean, I have my views about that. I think a lawyer can never be replaced. All these are only tools to assist. So that is one aspect. As far as a law student is concerned, I think it's very important that basic training, like you do your moot courts and mock courts. I think online training and how to appear in virtual scenarios, because I mean, whether you like it or not, whether it's a hybrid system or whichever system, virtual is definitely here to stay, according to me, and it's the future. I mean, I know how, as a network of lawyers, how we are working with colleagues around the world. All that is only been possible because of virtual, technology. Otherwise, each one of us would be in, uh, geographical and jurisdictional islands. So I'll pause there and be happy to take your questions. Thank you so much.
Thank you so much, sir. You have explained very vast thing, and you have covered various things like from cryptocurrency, disability, and other aspects. Like some comments I just saw, like some comments they have given like hats off to the sir. He is a complete library. It's really like you have deal with the various issues in this short period of time. I think if we have a 2 hour, 3 hour session also, it will be very less. So like, and we have to be restricted to some time. So we'll move to the Q&A. So first question is, how PIL came into effect, and when was the first PIL filed in India, and can you tell what was the issue and the judgment?
No, I think I had mentioned I mean, this is debatable, but I think according to me, the first PIL was the Doon Valley case, where uh, you know uh, NGO had written a letter to the Honorable Supreme Court saying that there was illegal mining in the Doon Valley, and the court not only took it up, but they also issued directions and guidelines for environment, how to stop. The illegal mining and environment pollution as a result of that. So the result was very positive, and I think they were able to ensure that a lot of environment damage was controlled. Of course, now things have changed in the sense we now have national green tribunals and those set up for exactly this purpose. So the sort of environmental issues per se going to the court has become slightly less. But that is also very interesting, the debate that is going on just now, that whether can can the NGT actually take up a matter on its own, or does somebody have to bring it to their attention? That is being debated currently in the Supreme Court.
Yes, sir. So, sir, I have a question. Like, what type of public issues we can deal in the PIL? Like, is there any specific areas for it?
No, I think, see, as the term suggests, anything that is first and foremost, okay, to be a public interest petitioner. Of course, now I have to add this caveat that every High Court and Supreme Court have their own rules, so you have to comply with those rules. Now, typically, what the rule says is that, see, to be a public interest petitioner, you should take up something for and on behalf of the public, and you ideally have shouldn't be somebody who's going to benefit from that. You might benefit indirectly, yes, but not directly, because if you do, then you should the alternate method or the writ petition is always available for you. But this is usually for the benefit of public at large, who in as especially when they started, for the poor, indigent, people who could never, like for example, bonded labor. Okay, they can't be represented, but somebody can take up an issue on their behalf. So things like that. But the gamut of public interest litigation has from I would say adoption to abortion to environment, I mean, potholes, for example, potholes death. I was, and the Americas, I mean, we had what, over 66 hearings in that particular matter. Your former Chief Justice, and now, of course, he's in the Supreme Court, Justice Oak's bench, appearing before them so many times. But the and it's very interesting because what happens is uh, it, it's like I would call it is like a little classroom, like somebody going to college and sitting in a classroom and your teacher taking you through the whole gamut and then finally coming out with guidelines. As a public interest petitioner, you must also come up, at least try and assist the court and give good suggestions. That is also a very important role. You can't just say that I'm bringing this to the notice of the court and then sit down. No, you should also do your research. You should also suggest things to court and be actively a part of the change, because this is the only way where judge-made law can substitute the written law in a vacuum or in the absence. So it's very, and usually you find that in PILs, directions are given from time to time. You never find that on the second day, you just have a judgment. No. So these are the interesting sort of development. Of course, I mean, there is a flip side of it. There is a misuse also of PILs, and courts are now impose sometimes quite stringent fines on people who are misusing this opportunity to do something good.
Yes, sir. As you told, the abuse of power. So, is there any particular law governing the PIL, or does judiciary regulate the PIL to stop abuse of power?
Yes, it is an inherent power that the court has, and when typically when it is, for example, a PIL is filed, the registry goes through your petition, and if there is any objections, they can raise it. You also give an undertaking under rules that you will, in case cost is imposed, that then you can't say that no, I didn't know anything and I'm not liable for cost. Of course, that is subject to review, but so all those things are there, and also I think now the over a period of time, everybody has become quite experienced. So if there is something that is frivolous, I think the court should, of course, your principles of natural justice is universal. They should give everybody an opportunity of being heard. But then if they find that it is frivolous, they have every right to throw it out and impose cost.
Yes, sir. So, is there any procedure to file PIL, and is this different from how it is different from the writ petition?
No, so I think writ petition is uh, uh, writ petition is again, as I said, where a person is interested in a matter in some way. That okay, I have a problem with a department of the government, or my property is there is a problem with that, or any issue with any department of the government. And the person is directly affected. I mean, by person, I mean it can be a corporate also. Corporate can also file a writ petition. You don't find corporates filing a public interest litigation, although it would be interesting if they did. I mean, there are sort of arguments both for and against that. But uh, the important thing is that the essence of a public interest litigation is that you must show that you are somebody who is, uh, uh, a public spirited citizen, and that you are taking up a cause that on behalf of a section of society who cannot be represented, who cannot come to court for particular reason. So that's the fundamental basis of public interest litigation.
Yes, sir. Sir, what's your take on the PIL being used as a tool to suppress the government policies by some political parties or other organizations?
I mean, I'm sorry, suppress the government policy.
Suppress means like
Huh.
anything.
No, see, again, in all this, you see, uh, I mean, suppose if somebody files something like that to say, I think the courts are smart enough to look and look through all these aspects, and they're if they find that there is no merit, or somebody is trying to use this as a conduit to do to make certain private ends meet, then they can do this at any time. I mean, even though certain so sometimes also what happens is, if they find that a petitioner has actually compromised his position, they can replace that petitioner and say that the petitioner is now out. We appoint an amicus because the issue that is involved is important, and therefore that should be continued. So that also happens sometimes.
Yes, sir. So it recently happened in this PIL against the Kaveri calling initiative also in the Karnataka High Court. Petitioner was removed and amicus curiae was appointed in this case also.
Yeah.
So we will move to the next question, sir. So, sir, does this pandemic affected the traditional system of PIL in any way?
Uh, See, it's again, people see the what the pandemic has done in the most forget about the whole issue about the right to health, and that's a separate story. It has sort of accelerated the use of uh, the virtual system, and I think uh, you know uh, we would never have imagined in real time the fact that the court, see, you have to understand that the court was forced into this system. Okay. And if you see, most of the platforms that are used and are currently business, whether it is Zoom or WebEx, they're all business platforms. The world over, the courts usually have their own clouds. So these systems are being built even now, even for India. So we're going to see a complete judicial cloud system that is being built. So I think that is accelerated. If you, I mean, this is in my opinion, I think the hybrid system where a person, just imagine, today, you have the Supreme Court in Delhi, for example. Okay, if somebody in, say, a poor farmer in, say, in Andhra Pradesh, he has an issue. Okay, now he hires a lawyer. The poor lawyer doesn't, say, appears pro bono for him. It's fine up to the Andhra Pradesh High Court, no problem. Then what happens? Then it goes to the Supreme Court. If otherwise, just the travel time that you fly or take a super fast train, go there, wait, matter reaches, doesn't reach, final hearing, no final hearing, come back. Even from a lawyer's perspective, such a lot of time and energy gets wasted. Here you have a system that it is possible to uh, you know uh, argue from your office, your residence, wherever you have, as long as you have powerful internet, uh, and you can do justice. You can do all your research online. I mean, I have done international research online, no problem at all, and all that has been accepted. So I think it's a great step in the right direction, in the sense that it can cut off unnecessary costs in filing a PIL. I think that is, very, very important. Uh, how is it argued? I think that also, uh, uh, it is important because you need to, for example, file your written arguments also. That is another very important process that quite often lawyers forget, especially not only in final hearing, but now even if your matter is being heard, say for admission, etc., it's a very good practice to have your arguments, in a written format, which you can email to the court and say, because sometimes, suppose there is a problem with the link or whatever, at least what you want to say is there, sorry, in black and white. So I think these, so a few things have changed, uh, but I think by and large, uh, I mean, see, the public at large must take this in a positive sense. I mean, and use whatever is available today as a stepping stone. The, undoubtedly, the future is virtual. There's no question that has been proven. How to make use of it and how to benefit is in our hands.
Yes, sir. So, a question from a participant: isn't live streaming a threat to right to privacy and concept of in-camera proceeding and also the social stigma attached to it?
No, I think all these issues have been. I suggest you read Sapnal Tripathi's judgment. It takes adequate care of all that. All those issues which involve where privacy and things like that have been taken care of substantially. The other aspect is in fact, if you see, courts are supposed to be open to the public anyway. Anybody can enter a courtroom. So I mean, there's no difficulty at all. And I mean, the higher you go, in fact, in countries abroad, you have television channels. It's like cricket. You have live relay, and then at the end of it, you even have highlights. And for example, in Canada, you have Supreme Court TV, where if you have missed something, you come home at night and watch the proceedings and see what you have missed. So I don't think that's too much of a problem. I think we are just not used to it, and I think we will get used to it. And there's nothing like transparency. And I think as Justice Sri Krishna said, and I virtually quote him, that he said, "What are we trying to hide? Is it the formula of Coke that we have that we are discussing? We're certainly not doing that. So there's no problem at all."
Yes, sir. There is no such secrecy in this. Sir, there is a question. Sir, if I have filed a PIL, can I withdraw that?
Now, there's nothing like withdrawing a PIL. You can go to court and say that it has become infructuous. So the PILs can only be disposed of. They can't be withdrawn. That's the difference.
Yes,
While a writ petition can be withdrawn. I mean, at
yes,
the end
sir.
of the day, it's the same thing.
So, next question is, sir, isn't live streaming and transcripts a potent patient threat to a
I
right
think
to privacy and in camera proceeding and also? Okay, it's done. I think.
we've answered this. There was another one before that, I think, which.
Yes, sir. The same question was there. Yeah. We will move to the next question. Sir, can this change in virtual hearing can be a solution to problems on pendency of cases in India?
Well, can virtual. Well, I think virtual can definitely speed things up, for sure. Uh, in the sense that if time limits are set, if arguments are short and crisp, if you use written arguments, and say on an admission day, if the judges and lawyers all come read, and the judges only asked you specific questions, I think then yes, it can definitely be a faster and a quicker. But feel that for a country like India, it is the hybrid system that is, like how you have a television program. Whoever can come to the television studio are there, who are not can certainly join on video wall, and this can happen simultaneously. And I think that that will help in our system currently. I think then people will feel comfortable. I think some people have a little bit of reluctance. Again, it's a matter of getting used to virtual. We've had, for example, no training at all, but still it's fine. And the other interesting thing I must say, in virtual, it gives the the whole issue of having a truly sort of all India bar is possible. Where you have people from all over. You can have lawyers, trial lawyers who are also, otherwise usually the trial lawyers restrict themselves to their sort of district court in their area, and here it is a great opportunity. They can also appear, they can also be part of so it's a very very good opportunity. I think people should grab it with both hands.
Yes, sir. The hybrid system is a key to like everything. Everyone can get the opportunity and cases can be solved speedy also. Yes, sir. We move to the next question. So, like, as you said about the like we were talking about the privacy and all. So, how far we can rely on the technology in respect of court proceedings? There should be any boundary to it, sir?
So again, see, technology should always be used as as a progressive tool. If you find that technology is not like for example, this whole question about AI, that will AI take over? I mean, it may do the routine and the mundane work, but can it replace the human mind? And uh, the fact that you can change track while you are arguing, and based on the question that is put to you by the judge, can AI actually do that? The answer is no. So you'll never be able to replace the human mind, and I think that's great, and that's the skill set of the lawyer. And the lawyer should always be you know in the forefront of and similarly for, so of course, for the purposes of research and so many other things, sure, no difficulty. But I think the fact that you have the a human being at the end of the day is the beneficiary of the justice system, so there should be the human element uh, involved in it anyway.
Yes, sir. I think I had some network issue in middle, so I was checking the other network. So we'll move to the next question, sir. So how far the data can be protected in the e-courts in the current scenario, and how Indian judicial system is planning to protect, sir?
No, again, I think you should read the document that the Supreme Court E-Committee has come out with on this on uh, sort of digitalization for the next three, or especially phase 2, phase 3. Oh, they have done a lot of work. They have some of the finest experts who are assisting them in this process, and I think they are uh, taking adequate care. There are a lot of international expertise that is also available for this particular type of data privacy and things like that. So I don't really think that should be too much of a problem.
Sorry, sir, I had some
Yeah,
internet
I have
issue.
answered the question in your absence.
I will look the answer later in the. I will move to the next question, sir. So, sir, According to you, every case is to be dealt in virtually, or there should be a classification of cases depending upon the severity of cases, sir?
So, so again, it's like this. I mean, I think at the end of the day, the court should follow a very practical, aspect. If today, if it's very, simple and easy, you see, even in the smallest of places, okay, very, very small places where the number of cases are not too many, and you have, most of the lawyers representing are from a, nearby geographically, having physical hearings and all is not an issue. It is, I think once you get to perhaps district level and above, that is where maybe, a hybrid system would be wonderful. And it's very, very simple, very easy. We have seen how it functions. You can, I mean, I've seen cases in the Bombay High Court where you have, you know sort of and even a mix and match. I mean, it's up to the court to sort of regulate its own roster. So that part is fine. But we've seen where you have had physical hearings, then you have some virtual, then again you have a hybrid. There's no problem at all. It's as per the convenience of everybody. So you just develop, and as long as it is, justice is meted out at the end of the day, I think that's absolutely fine.
So basically, goal of justice should be achieved, and
Yes.
any way we can do it.
I mean,
So
I'll
we'll
give you a
move to
good
the
example.
yes,
Just
sir.
one more example. For example, in Canada, okay, I've seen where suppose somebody is caught for a driving offense in the middle of the night. You sit in the policeman's car, he dials the judge, and the judge, at 2 a.m., 3 a.m., gives you tele bail, bail over the telephone. It's amazing. I mean, simple things like that. We have not seen over here. These are routinely being used abroad. So there you go.
So this change can be brought in the India. How you think, sir? Can it be practically possible in
Yeah,
India?
absolutely. I think see, we must again see we are see technologically we are among the best. Indians are everywhere. So there is no problem with that. The question is what to bring in and what not to bring in. You have people at the helm of affairs. And that is why I keep saying, you see, this is the first time ever in our history, that judicial history, that you have had a committee, a E-committee, which is actually given like a 5-year plan, saying that this is what we need to do to be up to date. Like for example, if a lawyer is doing an international dispute, why should he or she be overawed and say, oh, abroad it's like this? And no, even in India it's like this. We are used to it. We have among the best brains in the world. So what is the problem? So I think that's why we should technology should be there to assist. It's very simple.
Yes, sir. So we'll move to the next question, sir. Sir, if somebody has done sting operation of any meeting, to stop this type of sting operation, can we file a PIL by Nux? A question raised by Naxin.
uh, can you, I mean, there are ways of now, for example, if somebody is uh, I don't know as a result of the sting operation what has happened. I mean, I don't know in what capacity that question is being asked. But suppose somebody has maybe what they want to say is that can that be used to file a PIL and get directions against the media? Yeah. So, or see, against the media, there is such a lot of, jurisprudence that is now available. you know, it is, and it is a developing jurisprudence. It's, you know, I mean, uh, you have so many cases. I mean, whether it is from your Sushant Singh Rajput's case of, you know, online reputation to so many things, press council, Supreme Court has passed guidelines, high courts have passed guidelines. I mean, there are so many different things. But yes, I agree that, you know, at the end of the day, I think there has to be you know, a fine balance between. See, the media also has the right to report, uh, but if you sort of do a sting operation, then you do it with, you know, keeping certain things. And if the sting operation goes wrong, then you have to face the consequences. You know, maybe the criminal law justice system would be a better way to. Yeah, maybe a criminal PIL could be filed, perhaps. Why not?
Yes, sir. I hope the participant has got the answer what they mean. We'll move to the next question. How to encourage PIL filing at the student level or law student level?
Okay, so there are two sides of this. One is that if there is a genuine cause, it doesn't matter whether you are a law student or anybody else. You can take it up. In the past, there have been instances where to get more marks in your LLB, law students have filed, and this certain courts have, you know, passed remarks, have called principals to the court to tell them, listen, that, you know, this practice should not be followed. So I think, again, you know, there has to be a sort of a balance. So, you know, when some law students file, the courts appreciate them. And some of them, they say, listen, why don't you concentrate on your studies? So it's I mean, you know, as many judges, as many opinions. It is very varied. Yes, but I always say this, that if there is an issue and you genuinely feel and you have done sufficient research, then I think it makes a lot of sense. You can file. There is no question. You are a citizen of the country. You can file.
Sir, there is a question from the last person. Can we stop the media of doing sting operation related to the sting operation question?
I don't think you can stop the media, but there are enough and more ways of, you know, uh, uh, sort of ensuring that, see, for TRP, sometimes they do all these things, but, you know, uh, I think, you know, uh, responsible media, the courts have cautioned them. They've gone, the courts can, you know, impose sort of bans on them. They can do so many things. I mean, please remember, courts are powerful. They can certainly do a lot of things. But can you know, uh, stop a person, you know, committing a crime? The answer is no. You can't stop a person if he or she decides to, you know, do something which is, you know, hurtful or wrongful to another. Uh, the generic answer is no, you cannot stop, but you can certainly have, you know, the courts. I mean, they have. Let's be honest, uh, done a lot to sort of educate the media also to a large extent, to say that, you know, please don't, you know, go beyond this limit, because otherwise the consequences can be quite severe.
Yes, sir. So actually we can make file a cases, but we can't stop the sting operation then in this scenario. So we'll move to the next question, sir. Uh, how are the courts planning to deliver justice to people in rural areas as there is a lack of technological infrastructure in most of the areas? So how does judiciary dealing with this, sir?
Again, I think this one document you everybody should read. I think the vision document that the Supreme Court has come out with, they're very good system. They want to go, you know, from, you know, the lower courts to every single court. The fact that today, you know, the mobile phone has become a, a tool that is available in everyone's hands, and they want to go to each and every court, small or big, across the country, and it's going to take a little bit of time with regard to infrastructure, but once it starts, I think, as I've always said, then implementing and technology ensures that the implementation happens immediately. You don't have to waste time. So it'll take time. There'll be so that's why they said over 3 to 5 years it'll take time for it to happen. But and I think you have to give them that kind of leeway. We are doing it for the first time ever. So basic electricity, etc., is available at every taluka. I mean, yes, in a village, perhaps if there is a problem, they'll have to do something about it. But otherwise, by and large, in at least, uh, you know, maybe you have a problem at the village level, but anything above that, at the taluka or the district level, I don't think there should be a problem.
Yes, sir. So we'll move to the next question, sir. So as we know that area, okay, we have a question from participant. Can I file a PIL to modify an existing act, like filing PIL for reviewing Section 498A as abuses are being happened?
So there are two aspects. I mean, I would answer this more from the legal perspective. If you feel that there is a gap in the law, you can certainly write to the government asking for because technically the the law as far as the constitution is concerned, it goes through the process of the parliamentary process, where an amendment is sort of asked for. What a PIL can do, and it has done, and it continues to do, is the court can issue directions or guidelines that in the absence of the law, these guidelines or directions are necessary. And so it will be a stopgap arrangement till there is a amendment in the act. So yes, that you might be able to get through a PIL. Like, for example, in the abortion case, there were some directions, guidelines, etc., which held the fort till such time as the amendment took place.
Yes, sir. So we'll move to the next question, sir. Um, Online dispute resolution can become an effective form of alternative dispute resolution in this era, sir. What's your take on this, sir?
Oh, I mean, I'm very, very impressed by some of these, the ODR, arbitration, and I'll come to mediation later. Some of the platforms that are available in India are absolutely amazing. There is a time limit. It is very, very cost effective. You can do your cross examinations also now very, very easy. The camera system, etc., all have been proven. If there is enough provision for your data security, etc., and you save paper, save a lot of time. People from all over the world can join in, and it's absolutely amazing. It's probably one of the best areas where technology has really proven itself, and it's so cost effective. I mean, for example, an arbitration, physically, if you want to have it to get people together and at the same time, same venue, etc., it costs a lot of money. Here it can be done at, I don't know, maybe even 1/10 of the cost. And you know um, and I've seen that. We've seen some presentations that were made, and very, very impressive. Now mediation, they say people prefer to meet face to face, but there also I believe very large commercial disputes can be mediated. I mean, we have spoken to international mediators. They said that they are able to resolve them in 3 to 5 days. I mean, if that's the kind of turnaround time, then it's. Uh, and of course, I believe the law minister has made a statement that he wants to see India as an arbitration and mediation hub. So yeah, I think we'll are in for some very interesting times, if not exciting.
Yes, sir. So, sir, what is the scenario of PIL in the foreign countries, sir?
I think every country, different countries have their. I think we are quite well off. I mean, South Africa follows our system. South Africa even, has taken. In fact, many years ago, I met this Justice Yakub, who was a Supreme Court of South Africa. He was a blind judge, amazing. In Pune, I had met him, and we discussed this. So South Africa is a younger sort of constitution, and they allow the use of foreign judgments, including India, and that's made a lot of sense. In fact, several countries, just as we also, you know, uh, uh, permit the use, and you would find in environment matters and other matters, other you know uh, judgments of other courts. What I would love to see, okay, is much more acceptance of the judgments of other courts, even in our neighboring countries. I mean, if for example, Sri Lankan Supreme Court or Bangladesh or even Pakistan, if there are, or Nepal, for example, Bhutan. I mean, if you have, good judgments, why should, we not show them uh, to courts over here? Yes, I mean, they would be persuasive. We understand that. But if in the absence of a good judgment, it wouldn't be a bad idea to start looking at them. Uh, but I think the system in India is very good. A poor man can reach the highest court of the land in a uh, hopefully in a not so very expensive way through technology.
Yes, sir. So we have just some questions left, sir. And next question is, how did technology help the citizens to avail justice in the time of pandemic, sir?
So again, as I answered in the last question, I think technology. I mean, uh, the fact that you can, you know, uh, through a simple mobile phone, you can reach the Supreme Court if you have the access. Then I think it's a big thing. Otherwise, you have to go to Delhi, take a pass, you have to do this, that, so many other things by the time you reach the court. Here you could maybe send an email uh, to the Chief Justice, that gets converted, and then you sit in your house and argue from there. Isn't that as simple as it can get? It is possible.
Yes, sir. So it has also cutted the cost, as you said earlier, to of various citizens and also the lawyers also to
Of
travel and
course.
other things. Sir,
I mean, I'd
my
say
last question.
unnecessarily. Yeah, sorry.
Yes, yes, sir. Yes, sir. So my last question is, sir, did lawyers were ready to accept these changes, or what were the difficulties faced by them, sir?
So again, I think it's say somebody who has been used to going to court, physically on a day-to-day basis. For him, I'm sure it was a problem because of the pandemic, he could not go to court. Okay, but I think again, as as a lawyer, as in so many professions and vocations, uh, you have it teaches you. Pandemic has taught flexibility. Okay? It is the fact that you have to be flexible. You have to change the mode of your working. I mean, there are you know uh, pluses and minuses of the work to from home, for example. I mean, we don't have guidelines today. Even till today, we don't have guidelines. The bar associations and bar council has not come out with any specific guidelines for lawyers on this, which is an issue. But I think by and large, apart from that, it's been you know uh, simple. It's been sort of easy, and but you must uh, sort of ensure, you must think that you're doing like a regular sort of, as you were prior to the pandemic, and then slowly adjust yourself to that is what I think a lot of people have done. I mean, they've managed to work around. uh, I know sometimes, working from home, and there are other distractions and other problems that happen. And especially in India, our houses are not all that big. So, sometimes that becomes a problem. But otherwise, it's fine. And I mean, for example, if you're doing work with somebody who's far away, or uh, everything is remote, you can't meet that person all the time. I mean, I can't come to Bangalore all the time, right? So our uh, talk has to be remote, pandemic or otherwise.
Yes, sir, you rightly said, sir. We have to change and we have to acquire every other thing. So I think we have completed all the set of questions, and I believe that participants have enjoyed the session and acquired enormous amount of knowledge from this topic from your own experience. I have acquired a number of knowledge, so I think I expect same from the participants also. And before concluding the session, my last question to the sir is, what is your advice to the student and the youth to grow in this field? And any other advice you would like to give, sir?
Sure. I think this is a very interesting time to be a sort of a student of law. I think a lot of changes have happened. I think there's a great opportunity to become a global lawyer. I mean, I think don't look at yourself only as a lawyer in India. Yes, you have studied in India. You will learn everything from here. That's fine. But also use this, use technology, use the virtual system that you have in place to become a truly global lawyer, global citizen. A lot of people, uh, you know, are now looking, and they do appreciate the Indian brain. So I think it's a very good thing. And yeah, I mean, be flexible, and just see, as people used to say, law is like a jealous mistress. So it will keep on, but keep showing your enthusiasm. I am learning every day. I'm sure if somebody is 80, they are learning every day. So law is fascinating, and I'm glad I became a lawyer than something else.
Yes, sir. Thank you for this advice, sir. Now, I would like to conclude the session by thanking Advocate Jamshed Mistry, sir, for providing us time from their busy schedule and giving us the wonderful and the practical insights from their own experiences. And I would like to thank my team for making this webinar successful. And in the end, I would also like to thank all the participants for participating in the session. And also, don't forget to take the vaccine and be safe from this COVID-19 pandemic. Thank you, sir.